that time, depending on what their responses are, how we're gonna proceed anyway. But if you would, everybody's here, show the jury we're in. All right, ladies and gentlemen of the jury, I have received another note that says we are unable to reach an agreement. I won't ask for a show of hands, but do you think that further deliberations will change that? Is there any hope? Y'all invested a lot of time and effort in this. Everybody else has too. I don't want you tilting at windmills, but at the same time, if you think there's any hope that you may be able to reach a verdict in this matter, I want to ask you to continue deliberation. If you feel as a group that it's impossible to reach a verdict in this matter, I'd like to know that too. You spoke earlier. I don't know if that means you're the spokesman or not, but you spoke earlier. I'm going to, anyone have objection to me talking to the closest you are to me anyway, as to what's your thought? What's the jury's thoughts at this time?
I think it's impossible.
You think it's impossible? You believe that further let me ask you this a little further. Has your, without telling me which way it is or what count, which charge it is, has your numbers changed in any way?
No.
Do you anticipate that there being any hope of that taking place?
No.
If further deliberations resolve this? Jury, that another jurors that same opinion?
Yes.
All right. I thank you for your effort. You've been out there. You've been out 9.5 hours, I think. Have you reviewed all the evidence thoroughly? I'm going to declare a mistrial. I appreciate your effort. And I'm going to let y'all exit through the jury room. We've got the bus here yet?
Yeah.
If the bus is not here, it's almost here.
It's here.
All right, the bus is here. We're gonna carry you back, let y'all get your belongings, head back to Forest County. I thank you for your service. I know I've asked a lot of you. I'm probably the next couple of weeks gonna mail you a letter. Asking just, not about this case, but if there's anything that we can do to make your experience easier, better, not, as far as your accommodations, your food, if we ever have to do this again, at some point, in some case, we'll do it again. And y'all are the best judges on how to tell us to improve things. And if you've got any suggestions or things to how to improve our business, we'll do that. Thank you. We're going to get you on the road home just as quickly as possible. No one leaves the courtroom until the jury has had a chance to get out and get on the bus, okay? Thank y'all. I would like these notes to be made a part of the file. Court having declared a mistrial on this matter, I think that after 9.5 hours of deliberation, if it It doesn't, just my reading of the jury, I think we were hopelessly deadlocked. I'll entertain y'all sometime in the next week or two about possible court date, trial dates for a new trial. I'm going to assume that there was asked for a change of venue in this case on this trial. If y'all can give me your thoughts on whether that's going to be the request for a new trial or not. If so, you can submit counties about where you would like to consider, okay? But court's going to declare a mistrial at this time. All right? Sheriff, if you would let me know when the bus gets gone anyway. I would ask this, that parties on my right side of the courtroom leave first, then the parties on the left side of the courtroom leave at that time, okay? Not that I would expect any problems, but I don't want any problems anyway. All right? Alan, look out the window there when you get a chance.
Just about there, sir.
Do what?
Just about there.
Okay. I will ask the state to prepare an order next couple of days declaring a mistrial in this case. Y'all consult with the court about possible trial dates sometime in the future.
I assume the defendant will remain on the same line.
The defendant will remain on the same bond. I assume the defendant has been out of jail. Those bonds have an expiration date. I don't know when exactly the bond was made, but let's consult, check into that, make sure the bond is not, if the bond is approaching retirement, aging out, let's see about making a new bond, okay?
I'll check that while we're here tonight.
He'll remain out on the same bond, but sometime in the next week or so, based on the timing of it, it cannot be 3 years old yet, but it could be getting close to 3 years. And if it is getting close to 3 years, as it approaches 3 years, I will make sure that we have a good and proper bond. Okay. All right.
Yes, sir.
Okay. If you would, go ahead.
Governor, I know there's still a lot of media coverage, and there may be media that attempts to contact.
I did meant to mention to the jury that they have the right to speak with someone. I'm gonna let the jury know, because they're not headed back to Hattiesburg yet. I'm gonna get the word to the jury. They have the right to speak with anyone about their jury services they wish. If they do not wish to speak with anyone about their jury service, tell them they don't want to. If they persist, to contact the court, okay? Anything else? All right. I'll contact the bailiffs and let them know that now anyway, okay? All right, if this side of the courtroom would exit, please. Did the alternates get on the bus?
Yes.
The alternates?
Yes.
Okay.
Everybody.
Uh,
All right, guys. So there you have it. We're watching right now. It was 11-1 mistrial. If you're just tuning in, 11-1. We don't know whether it was 11-1 for guilty or 11-1 for not guilty. So I want you all to know that. But it was 11-1. There was one holdout. The jury said they were hopelessly deadlocked. And what you're seeing, what we were watching there was the families filing out. So unbelievable stuff. So, wow. That's all I can say on that is wow. Hold on here. I want to get this up here. Declared the one deadlock. All right. So there you have it, guys. 11-1. Well, Jamie. Basically, what's going to happen now, as I said, like this could be, it's a victory temporarily for the defense, but you have to remember in a case like this. Now, I was, doing some listening or watching or observing in the chat. There's allegedly a funeral home in Grenada that everybody thinks that was connected to the family, that there's no chance this body gets found. So the risks of the body being found apparently is low. But yes, Deanie, basically here's how this works, okay? Now the state, they will have a hearing. They're going to, as the judge said, they're going to get together on another hearing. The state will get to decide. Now, if it was 11-1 not guilty, the state could, in theory, decide not to go forward right now at this time, and they could dismiss the charges. Now, if they dismiss the charges, it doesn't preclude them. I don't believe it precludes them, although I'm not 100% certain. I have to look that up. I'm not 100% certain. I think it might. I think jeopardy might attach because they've already had this trial if they were to choose not to retry him, although I'm not 100% certain on that. But they could choose to not try him again. However, I think they're going to try him again. And I think next time it's going to be a different scenario because next time they're going to fill in the holes. Remember, historically speaking, second trials always go worse for the defense because they come in more prepared. The state comes in more prepared. The defense has unloaded its best theories and raised all these questions. And remember, every question that the defense raised, the state is going to come back and fill those holes. They're going to come in and bring a witness in to fill the holes on the lock. They're going to bring in a witness to fill the holes on the car. They're going to tighten this thing up. Yeah, well, I don't think so. What I'm saying is, Kate, is if the state were to decide to dismiss, in other words, if the state decides not to try the case, they would, whether or not it would attach at that point, since they've already had a trial. I don't believe it does, but I think they would still reserve the right to retry, which means down the road, right? If this body ever gets found or something happens. And in some ways, I feel like a good strategy in this case would be to almost make him believe that he is, bulletproof here and dismiss the case.
Arguments and bases.
Dismiss the case, or at this point, and then sit back and see what happens. No. I'm not, Kate. I'm not saying I know he didn't. I'm not saying that. What I'm saying is the state, if they were to dismiss the case, in other words, if they were to decide not to try the case, whether or not at that moment, if the state would have to dismiss, if the state's only option is to dismiss with prejudice, if they do, I'm not certain in that instance there, because he's already been tried once, and I'm not sure if it's just state by state or if it would be obviously state by state. It would be each state would find it, but I'm not sure if in Mississippi if they would allow the state to just dismiss the case. Well, right, they don't have to refile. They don't have to refile. What I'm saying is they do have to. Is the state would have to make a motion? Okay, if they chose to not go forward, they would have to dismiss the case. And if by doing so, would they have to be? Is their only choice to dismiss with prejudice? And that's what I'm not certain about, since the mistrial's already happened. But I think they're going to retry the case. But I would say, what I'm saying is that if they could dismiss the case, right, give him the appearance that he thinks he's beaten it, and then sit back, get a phone tap, listen in on him, now Richard, it depends if it's 11-1 guilty. That's the thing. We don't know, because it was never announced, if it was 11-1 guilty or if it was 11-1 if it was 11-1 not guilty. We don't know that yet. So that's something that we will find out soon, or when the jury talks. Now, what I found interesting was, and I guess maybe it was just the way this was, is in a lot of times, like in the Karen Reed case, it was later found out that 12 jurors had acquitted him of the top charge. And like in the David Swift case, they acquitted him of the top charge. I'm surprised they didn't ask for the jury to say, what were you hung on? Were you hung on manslaughter? Were you hung on capital? Were you hung on first degree? Where were you at? Had you already determined? Because they can't get to manslaughter until they've determined as a body that, hey, capital isn't happening. So there is a possibility they could have said, you know what, we all agree capital's not here, but we have 11 on manslaughter and 1 not guilty. And if that's the case, technically speaking, under the law, they've acquitted him of second, first, and capital. So the next time they come together, but again, they may not have wanted to do that. They could choose to refile or not. Well, but Kate, they don't have to choose to refile because the case hasn't been dismissed. What I'm saying is, right now, as the judge said, they're going to have a status hearing. They're going to schedule it. But in some cases, when they come to the status hearing, they could file a motion to dismiss the case based on if it was, say, 11-1 not guilty. Right now, the case is still active. That's why the judge was talking about the bond, and they've got to make sure the bond stays perfected. And in Mississippi, a bond only stays good for 3 years. So the mistrial didn't do anything to the charges. He's still charged. They're still active. What I'm saying is if they were to go back and look at the case and realize it was 11-1, and the jury says you got a bad case, no point in retrying this, and they were to come back and say, you know what, we're going to, yes, it is still active, Kate. It absolutely is still active. They don't have to refile anything. It was a mistrial, so the charges are absolutely still active. 110% they are. And I'm talking about this case right here, not the Karen Reed case, which is still active. But they don't have to refile or reindict or do anything like that. No, they do not. They absolutely do not, Kate. They do not. Look it up. They do not have to refile. And look at the Ty Tucker case. He did not have to do that down in Florida. No, you do not have to. They don't have to refile charges or reindict. Now in the David Swift case, they did have to represent because of the way of the charges he was indicted on and the way they indicted him. There was, and again, that's actually the reason why that hasn't come back or been reset for trials, because that's going to be going to the appellate court because on whether or not the indictment would stand. Cite what? What are you talking about, Kate? Cite what? What am I citing? I mean, I just sent you reference cases. Look at the Karen Reed case. They didn't have to refile on the Karen Reed case. They didn't have to refile on the Tyrone Tucker case. Those are active cases that just, the Tyrone Tucker case just came through, and it was a mistrial. That was in Florida. They do not have to refile. The judge, go back and listen to the judge. There's nothing to cite. Go look it up. Look up what happens after a mistrial. They do not have to refile the charges. The charges are still active against Tim Herrington when you have a mistrial. The only thing that happens is they declare a mistrial, and then the state will be retrying the case at this point. In the event that the state were to choose to not retry the case, they would then have to file a motion. The only thing I'm questioning is whether or not, when they file that motion, if they were to decide to dismiss the charges, because they didn't want to retry after a mistrial, whether they would be required to dismiss with prejudice or not. That's the only thing that I don't know. But right now, Tim Herrington is still under charges, still under indictment, and still is out on bond, and still is not a free man. He's not walking around today off home confinement. He's still confined to his home, and that was all discussed by the judge. That's why the judge was having a discussion of bond, because a bond in Mississippi only lasts for 3 years. And in the event that the bond expires, he would have to return to the jail and get a new bond issued. And that's why he was warning Mr. Herrington to make sure, because they're coming upon 3 years. And it's very likely in this case that before they get back to trial, I am quite certain Kevin Horan is going to take the issue that came up in regards to the defective indictment, and that will be going to the appellate court on whether or not they can proceed, and whether or not the indictment was defective or not, and whether or not they're going to be able to proceed on capital charges, whether or not maybe they might not be able to proceed at all, because once the trial started and they didn't have a correct indictment, technically speaking, it was a defective indictment, and as a result, they were proceeding on a defective indictment, and as a result, the remedy for that is dismissal with prejudice. Prejudice attaches, and they can't retry them. What's that? Do I have a Juris Doctorate? No, but Kate, if you obviously you're new around here, in terms of my background and where this channel's come from. But my dad was a very well-renowned criminal defense attorney. He's since passed on. I spent my entire youth around him in his law firm. I helped him. Again, it's a long history, but I have an extensive background in following criminal law and with. So I helped my father try his own case that I was his, technically his paralegal, so to speak, but I have a extensive background within, and he was like I said, he was a very well-renowned criminal defense attorney in West Virginia, who, so I have a broad knowledge, and he and I started the channel together. Unfortunately, he passed away in February. So I've kind of continued the spirit of that. So that's where I kind of grab my knowledge from as far as the law, because I've been around it. I've been at his law firm. I worked as a clerk at his law firm. I was going to become a lawyer, but for reasons of various reasons, I went into finance instead and went that way, but then found our way back to doing various different things with the law and helping people, and being around the law, and like I said, extensively understanding it and just having a foundational understanding. So, that's the background of the channel. So, do I have a Juris Doctorate? No. Do you need to understand some of these things? No, you don't. So, there you have it. At Richard, do you think he hit it or disposed of it? I think he's out on bail at just as the process can confirm. No, he is out on bail. He is out on bond. Absolutely. That's why the judge was talking about the bond and that the fact that his bond could expire within 3 years. As far as do we think he hid it or disposed of it? I mean, I think it's pretty clear that that the body's been hidden or disposed of somewhere. And I think, I think in all likelihood, like I said at the beginning of today, there's two worlds we operate in. There's the real world, and then there's the courtroom world. In the real world, we know Tim Herrington had something to do with this, and we know he was responsible for the death of Jay Lee, and we know he's also responsible for the disappearance of the body. I don't think there's anyone in the world that should question that in the real world. In the courtroom world, the question is, did the state or can the state prove beyond a reasonable doubt that he was responsible for Jay Lee's death, and in what way, form, or method was it? Was it manslaughter? Was it capital unaliving? Was it first degree, second degree? Was kidnapping involved? And that's where that's where the problems have arisen for the state, because you can think he almost was. You can think he most likely did. You can think he absolutely did. Not absolutely did, but you can think he almost did. But if he's not, if you have a doubt, even one doubt, that in as to whether he about any element of the crime, and in the capital unaliving charge, then that's what Kevin Horan was arguing. If you doubt the aspect of whether or not he was luring him there, and you think that didn't exist, then the capital goes out the door. So then you come in to say, then you come in and you say, okay, we have first, second degree, and we have manslaughter. And that's the problem. Do we know what happened? Do we know if he did it? Do we know whether or not it was something that happened in the heat of passion? And the state has to prove definitively beyond a reasonable doubt. So if even one doubt exists in that whole process, the jury's got to return a not guilty verdict. And that's why at the end of the closing argument that Kevin Horan presented, and when he went through the evidence and he tied in all of his questions, and he tied in the whole presentation of the defense case, it became clear that there is reasonable doubt in this case. That the real world perspective that we think, well, he probably had something to do with this, doesn't reach the level of beyond a reasonable doubt in a courtroom for any of the four charges that he was charged with. And that's why we don't know if 11 people felt that way and one person just didn't want to see the man walk out of court free, or if 11 people said, no, the Snapchat messages were enough and we'll make the jump over the Rubicon to guilty and fill in the holes like a lot of juries do, or a lot of jurors do. And one person stood strong and firm and said, no, not for me. This case is not strong enough. And hopefully we'll find out, because I'm sure somebody's going to talk. I said, please hit the like button. It helps move the channel up. Yep. Thank you very much, Jamie. I appreciate it. And Kate, what do you mean? What happened to the presumption of innocence? Who's not presuming anything? Because the presumption of innocence, I think at this point, again, when you're talking in a real world sense, absolutely. Well, today he's got a presumption of innocence. When he walks back in that courtroom again, he has a presumption of innocence. That's what I'm talking about. There's the courtroom world, and then there's the real world. Out here in the real world, we might say to ourselves, it feels like he probably did this. It looks like he probably did this. But because of the presumption of innocence, and the fact that to remove the presumption of innocence, you must prove beyond a reasonable doubt, not by preponderance of evidence, which is 51%, not by a reasonable suspicion, not by clear and convincing evidence. You got to go all the way up the ladder, all the way up the stairs, so to speak, to beyond a reasonable doubt. And that is the only place you go to remove the presumption of innocence. And any conflict of evidence, anything you don't know, gets resolved. So when Kevin Horan presents to the jury and says, we don't know if you can trust us or not. We don't know why there's doors opening at this time and there's doors open. And the state can't answer it and I can't answer it. So guess what? The law tells you you've got to presume innocence. you've got to presume innocence. And that is the only way you resolve conflicts such as that. And in this case, like I said, once you got to analyzing the case from the correct perspective, and from the perspective of proof beyond a reasonable doubt, and coming from a presumption of innocence and not a presumption of guilt, the whole case started to fall apart. And that's exactly what happened back in that jury room. And like I said, we don't know if it was 11 people that thought he was innocent, or if it was one. But yeah, so the next stage will be for them to come together, and like I said, there's going to be a lot of issues and things that are going to have to be dealt with and rectified coming out of this case. Like I said, the biggest one of them is going to be dealing with the issue of whether or not the state messed up to a degree that maybe they lose the entire case, or maybe they lose the ability to bring a capital case next time. And in Mississippi, that's the difference between life with or the ability to lock him up with life without parole. So that could have a huge impact on it. But anyways, guys, so we're going to call it here. It's 10 o'clock. But for those of you that are looking for a trial to watch, we're watching the Ferlazzo trial, which tomorrow I believe is going to go to closing arguments because everybody's rested. And then we've got the horrific case down there in Georgia with the baby beating case. So we're covering that one as well. So if you guys are looking for some trials, those will be up and watching, and we'll go from there. So anyways, until tomorrow, I'll see you guys later. As you guys can see, I gotta jump off here. I've got a little one here that just woke up. So I'll talk to you guys soon. I appreciate you guys watching, and let justice prevail. And hopefully we'll be seeing you guys for the retrial whenever that should happen.
The system's rigged, man, it's time to break free. Eyes wide.